Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, last week, our Supreme Court took a wrecking ball to several well-established legal traditions. The only one that we talked about on this channel was New York's rather oppressive and ridiculous concealed carry law. But in addition to that, we know that at least 4 cases, 2 involving magazine ban, 1 involving an AR ban, and 1 involving some more ridiculous concealed carry laws were GVR'd, granted, vacated, and remanded by the Supreme Court to their respective circuit courts. That was very good news. We talked about that in this video here. Then, as the final coup de grace to the session, we had an opinion come out that was called West Virginia versus EPA. And many of you asked a lot of questions about, hey, what does that really mean to perhaps the ATF? So I've had a chance to go through this. We're going to spend a few minutes talking about just that today. So let's spend a few minutes today talking about how the Supreme Court just boxed in the EPA and what that means for the ATF. Okay, so the case we're talking about right here, and it took me a few days to read through it because unlike New York Pistol and Rifle Association, which was long and thick and exciting and interesting to read, West Virginia v. EPA is long and thick. And, you know, you can imagine how much environmental law I studied in law school and have studied since then. So, yeah, for those of you who are having problems sleeping, I do recommend this opinion. But first, before we go there, I want to be proud to announce that this video is being sponsored once again by Legal Heat. Now, Legal Heat is the largest trainer of concealed carry classes nationwide, having trained over 200,000 people since their inception. In Washington State, they have trained over 6,000 people. They do training in all of these locations right here, and their hope is to train another 4,000 Washington residents today. You can learn more at mylegalheat.com, and if you use the promo code Washington Gun Law, that's Washington Gun Law, all one word, you will receive $10 off. For more information, again, visit them at mylegalheat.com. Okay, so I've gone through this and I struggled with how could I make a video about an incredibly boring case and not bore the living hell out of you. So I'm going to try to hit just a few bullet points and understand that I'm probably going to geek out on this a little bit more and dig into this more and get some more thoughts and ideas out there. But this is where we're going to kind of give you a sketch because, yeah, listen, if you're the ATF, I think that this court, which has definitely demonstrated that they have a little saltiness, a little orneriness in them, has told the EPA to basically go stuff it. And if you're the ATF, you might want to pay attention to what was said here. Okay, now this case involves a really huge issue that has been a central component of every argument that's ever been levied about the ATF. And that, of course, is the separation of powers. Yes, our government is supposed to have 3 branches of government. Article 1 branch, the legislative branch, that's the people's branch. That's the Congress and the Senate. We elect all those individuals. And Article 2 branch is the executive. Now, the executive does not make the laws. The executive branch only enforces the laws. The laws are to be made exclusively by the legislative branch or an Article 1 branch. And then, of course, we have our Article 3 branch of government, the 3rd branch of government, the judicial branch, which is to be independent of all sides. And their job is to interpret the laws as passed by Article 1 and enforced by Article 2 to ensure that they are lawful and not in violation of our individual constitutional rights. Now, the issue in the West Virginia EPA case is one where the EPA had adopted a litany of new regulations that were intended to move America's power system from coal and gas burning to more green, renewable energy. Sound familiar? Okay. The regulations that had been adopted by the EPA, not passed by Congress, but just adopted by the EPA, essentially was going to shut down every single coal plant in the United States and most gas burning plants. And of course, those in green renewable energies would have made out like bandits. Now, this is a significant economic shift within the energy industry, a significant shift. So the state of West Virginia, who does have a financial interest in the coal industry, sued the EPA in federal court. The case made it all the way to the United States Supreme Court, and this is important because I want you to pay attention to this, okay? The question that the Supreme Court was faced with is to what extent can a regulatory agency, which is part of the executive branch of government, create, adopt, interpret, and establish rules which Congress did not specifically authorize them to do? Or, put more simply, is some things that regulatory agencies do so big, so important, that a regulatory agency should not be doing it? Now, in a 6-3 decision voted along the conservative liberal lines delineated right now in the court, the EPA's regulatory scheme was struck down as violating the separation of powers. But the majority opinion, who was written by Chief Justice Roberts, and now let us recognize that Chief Justice Roberts, although he's considered to be a conservative judge, has really proven to be a very middle-of-the-road judge. He is by far the moderate on the court. But in striking down these ridiculous EPA regulations, Justice Roberts wrote, "Capping carbon monoxide emissions at a level that will force a nationwide transition away from the use of coal to generate electricity may be a sensible solution to the crisis of the day. But it is not plausible that Congress gave EPA the authority to adopt on its own such a regulatory scheme as in Section 111D. So think about that. They're saying that, listen, the idea, even if the idea may be a reasonable one, like, for example, some type of an AR ban or a magazine ban seems reasonable to solving the gun violence problem. I'm not saying that's what I believe, but we're just using this for the sake of our hypothetical here. That alone doesn't justify the regulatory agency making the action. Justice Roberts then went on to state, "A decision of such magnitude and consequence rests with the Congress itself or any agency acting pursuant to a clear delegation from that representative body." So what Justice Roberts did, and as well as Justice Alito and Gorsuch, who wrote concurring opinions, they talked about what is known as the major questions doctrine. And the major questions doctrine is that, listen, when an agency that's been delegated some authority by Congress starts creating new regulations or interpreting pre-existing regulations, sound familiar, and they make a decision which has a major political and economic significance to the American people, that absent a very clearly enunciated delegation of that authority from Congress saying, we now give this agency the authority to do this, then that agency is acting outside the scopes of the separation of powers doctrine. And these core arguments, this separation of powers argument, which is at the core of all of the criticisms of the ATF, goes back to the very formation of this country. The Federalist Papers specifically stated, "It is vital because the framers believed that a republic, a thing of the people, would be more likely to enact just laws than a regime administered by a ruling class of largely unaccountable ministers." And consider what James Madison said about this. "By vesting the lawmaking power in the people's elected representatives, the Constitution sought to ensure not only that all power would be derived from the people, but also those entrusted with it should be kept in dependence on the people." And so when we talk about what the ATF has done throughout history, and if we talk a lot about what the ATF is doing now, suddenly redefining the meaning of a machine gun, suddenly defining the meaning of a silencer, suddenly redefining the meaning of a short-barreled rifle. As you can see, these redefinitions, these reinterpretations of the law now exponentially expands the scope of the law and the control that the federal government has over individuals' activities and the commerce that's associated therewith. If this is the standard, by which administrative agencies are going to be restrained moving forward, then ATF, you got some dark days ahead. Once again, the case is West Virginia versus the EPA. It's a long read. I wish it was an exciting read, but it's not. Listen, you may have more questions about this case or anything else related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.